Several remedies exist for breach of contract, including specific performance and monetary damages. The victim of a material breach, however, may be permitted to rescind the contract. In B&B Equipment Company versus Bowen, the defendant argued that his failure to meet his contractual obligations wasn't a material breach. L.D. Brayman, Robert Jacques, and William Hughes owned B&B Equipment Company as equal shareholders. When Brayman retired, Jacques and Hughes agreed with John Bowen to take Brayman's place in B&B as an equal shareholder. Because Bowen couldn't pay the required $15,000 for Brayman's 100 shares of stock, B&B agreed to buy the shares from Brayman and resell them to Bowen for the same amount. Bowen paid $2,500 directly to Brayman, while B&B gave Brayman a note for the remaining $12,500. Bowen was entitled to all dividends on Brayman's shares, which he would then pay back to B&B to apply to the outstanding stock purchase price. B&B would deliver Brayman's stock to Bowen when the applied dividends totaled $12,500. Bowen took primary responsibility for keeping B&B's corporate records and books, in addition to working full-time for the corporation, doing whatever was necessary. At first, Bowen performed his duties satisfactorily and repaid several $1,000s from dividends he received. But then, Bowen began spending more time on outside business activities, including real estate sales, which he did from B&B's offices. He neglected the bookkeeping, skipping tasks such as reconciling bank balances and tracking inventory. Warnings proved unavailing. Eventually, B&B fired Bowen. B&B informed Bowen that it was rescinding the parties' agreement and tendered to him his original $2,500 payment, plus the total amount of the dividends he'd repaid toward the stock purchase. When negotiations broke down, B&B sued Bowen, seeking a judgment declaring its right to terminate the parties' contract. Bowen counterclaimed for a declaration that the contract remained valid. The trial court ruled for B&B, finding that Bowen had breached the contract and that B&B was entitled to rescission after refunding Bowen the funds B&B had received under the agreement. Bowen appealed to the Missouri Court of Appeals.